In Korea, if you rent a store and continue to operate after the lease term ends without signing a new contract, the law sees this as an automatic renewal by implication. This is called implied renewal. It is common in real business situations, but there are legal consequences you should know. Under Korean civil law, if the tenant keeps using the property after the lease ends and the landlord does not object, the lease is automatically renewed under the same conditions. However, this renewed lease can be terminated by either party with notice. If the landlord gives notice to end the lease, the contract ends 6 months after the notice. If the tenant gives notice, the contract ends 1 month later. However, if your lease is protected by the Commercial Building Lease Protection Act, the rules change. In cities like Seoul, if your deposit plus monthly rent times 100 is below a certain limit, the law applies. In this case, when the tenant gives notice to end the lease, the contract ends 3 months later. So if you have been running your store for 15 years without signing new contracts, the current lease is considered to be renewed by implication. If you want to stop business and get your deposit back, you must first send notice of termination to the landlord. After 3 months from that notice, the landlord is legally required to return your deposit. Even if your original contract says the deposit can only be returned after the full lease period ends, that condition may no longer apply because the current lease is not a fixed term but an implied renewal. To protect yourself, send the termination notice in writing. Using a document like registered mail is helpful as proof. If there may be a legal dispute, talk to a lawyer to get clear advice. Also, if your lease terms or deposit amount are not clear, check first whether your lease is protected under the Commercial Building Lease Protection Act.